The next consideration to keep in mind is objections. So the objections are basically what we've already talked about. So I'm going to review them quickly here, but they really don't change in meaning from when we talked about them with interrogatories. So we have our privileged objections, most common ones, attorney-client privilege and work product privilege. The work product privilege one is the one that is a little more of a concern, not because we're making the objection, but because we don't want to inadvertently send our privileged information, our work product, to the other side. And I'll talk about that in a minute. But what you need to be careful of when you're pulling up documents to respond um, to a request is any part of the document privileged. You may have situations where a whole document is privileged, but you probably will have situations where part of a document is privileged. In that case, we redact, REDACT, we redact or remove the privileged information. In the old days, we would redact the information by making a copy of the document and either blacking it out or putting a piece of cardboard over the privileged part of it. We would write redacted attorney-client privilege, make another copy, and then send it to the other side. And so there was no way they could see what was actually being covered. With programs and the way we store information now, you will have the ability to do that electronically, to redact information, mark that it was redacted, and then send the rest of the document on. So the fact that there's some privileged information in a document doesn't mean we can avoid sending the whole thing, because if other parts of it are responsive to the request, we still have to send it. But we do have to review documents carefully to make sure that there's nothing within a document that would be protected by either attorney-client privilege or work product privilege. We still have the overbroad objection that we've talked about. So again, you're going to run into that objection if you do not limit the scope, and frequently that is a time frame issue. But if it is too broad, you're asking for relevant information, but you're almost asking for more than what's relevant, and that's when you get the overbroad. You can get the same objections for vague, ambiguous, indecipherable. So if it's just poorly written and the recipient is unclear about what you are requesting. We have the relevancy objection. They're asking for information that is not relevant to the case. Keeping in mind, relevancy is something that tends to prove or disprove a fact of the case. So if it doesn't seem relevant, we can object that it's not relevant. If we get multiple requests for the same exact information, we can object to the identical request as being duplicative. We do not have to keep sending the same information if we've already done so. So we have that objection. We also have if you have a situation where information is protected by trade secret, something along those lines, which we've already talked about, that's an appropriate objection. If you have information protected already by a confidentiality agreement, that is an appropriate objection as well. So basically the same exact ones that we've already talked about. And then the last thing wanted to mention, and we really discussed this in great detail in the ethics course, so I don't here, but this is where this issue will occur, and that is the inadvertent disclosure of privileged information when we are responding to requests for production of documents, especially when we are dealing with a large request and there's a lot of documents that we have to go through, and we inadvertently, mistakenly, send privileged information to the other side. So we already talked about in federal court cases, a lot of times the parties will agree on to have a clawback provision. And so if that information is inadvertently sent, you can exercise that clawback and basically just ask the other side to send it back and destroy it, not use it. We don't see that as often in Pennsylvania state trial court. We can certainly have those agreements, but what you want to make sure you do as a practical matter is that if you believe after the fact privileged information has been sent to the other side, tell your attorney immediately. Don't sit on it. Don't wait to see if it becomes an issue. Tell your attorney immediately. These mistakes do happen. They are fixable if we deal with it in a timely manner. And so it may be your fault, it may not be your fault, but tell the attorney. If you are on the receiving end of what you think is privileged information and you know the other side sent it without meaning to send it, let your attorney know immediately, because ethically, your attorney has the obligation to notify the sender that this has occurred. So you need to make sure your attorney can comply with the ethical rules. I would also encourage you to just put that information aside. Don't read it, don't copy it, don't get stuck in it, because if it is, in fact, inadvertent disclosure of privileged information and we're not able to use it, we have to basically act like we don't know it, which is very difficult to do. So it is something that happens. Sometimes it can happen in other situations. You put the wrong letter in an envelope. The letter you meant to send a client, you put in opposing counsel, or you send an email and you choose the wrong email address, or you attach the wrong attachment and send it. All those types of things can be the inadvertent disclosure of privileged information. So however it happens, if you're aware of it, notify your attorney at once. It is a much less of a mistake, much less harm that can be done. It's easily rectifiable if we take care of it as quickly as possible. If you're on the receiving end, let your attorney know immediately. Don't do anything with that information. Just kind of ignore it until you know. And like I said, we talk about it a lot more detail in ethics, but this is where it tends to come up is with document requests. That's where we see a lot of the cases. So I like to mention it here. And then the last section we're going to talk about is the inspection of property. So this is still under the request for production of documents discovery method. So this is not a separate discovery method. It's still part of request for production of documents. And again, the rules are a little bit different from parties and non-parties, just like they are for the document part of it. So for parties, basically the same thing as the request for production of documents. You just draft it and serve it. No big deal, no big process to go through. The one thing you do have to do is describe with particularity the property to be entered and the activities to be performed. And if you look at 4000, Rule 4009.32, it actually lists a bunch of activities. What you find in practice is that a lot of times attorneys will just take that whole list of activities and put it in the request. Because sometimes you don't know what you need to do until you actually get on the property. So a lot of times people will just take that list of activities and put them in the request, and that kind of covers all their bases. But you have to, like I was saying in class, you want to get onto property to check the foundation of the building. Then you're checking the foundation. It doesn't mean you have the right to check the entire building. And then what do you plan on doing there? And again, you take the wording usually straight out of Rule 4009.32 and put that into your request. The party who receives the request can object to it, just like any other request. They have to do so within 30 days. And so if they don't object within 30 days, they have to allow the inspection. And they certainly can allow the inspection sooner than 30 days, but that's the longest time frame they have to decide whether or not to object. And then otherwise, it's allowed. Also, keep in mind these rules do state that we can access property one or more times, whatever is necessary to accomplish what we have put in the request. So for instance, you get on the property and you look and you see what you need to do, and now you're like, okay, we need to take measurements, or we need to bring an expert in and look at it, or something like that. You can come back onto the property to accomplish the goals of that initial request. So we cannot do it, obviously, to just annoy the other party and to become burdensome and a pain. We have to have a legitimate reason, but we are not limited to just access one time if it is in fact necessary to access it more than once to accomplish the goal set out in the initial request. Then Rule 4009.33 starts the rules regarding non-parties. So same deal. We have the right to request property in the possession of non-parties if it's relevant to the cause of action. Procedurally, it is a little bit different. In this case, we have to give notice in the form of a motion and serve it like original process onto that non-party. So keep in mind, this non-party sitting there has no idea, may have no idea this case is even existing. and we want to get on their property to see something. So they have to be served like original process. So generally that would be like by the sheriff, and it's in the form of a motion. So it's a motion to inspect property, basically, is what you'd be calling it. We have to give a copy to all the other parties, but we do not have to get their okay ahead of time. We do not have to serve it on them ahead of time and give them a chance to object. So it's very different procedurally than the request for or the subpoena for production of documents. We just have to give them a copy. And basically, when we serve a discovery request, we always give copies to all the parties. So that's nothing new or different. So the big difference here is we're drafting it in the form of a motion and we're serving it on the non-party like original process. Okay. And if you look at these rules that deal with it, you can see the language very specifically that we would include in the motion. It really is provided for us. And the non-party has the opportunity to consent. If they do not consent to us accessing their property, then we take that motion and we file it with the court and we set it for hearing. And then it is up to the court to decide whether our access to the property is appropriate. Okay, so there might be another step involved in this. We may have to go to court to be able to access it, but because it is a non-party, we serve them with a motion. If they do not consent, we file the motion with the court, and then you would get a court order allowing access to it. When you're serving this request on a party, you just serve it on the party. They have 30 days to object. If they don't object, then they have to allow access. And if they don't allow access, then again, we would file a motion to compel discovery with the court to get access to it. So again, procedurally, just a little bit different how we deal with non-parties versus parties, but we can inspect property relevant to the case, regardless of under whose control or possession it is. It's just procedurally, it's a little bit different. Terminology is a little bit different, but we have the right to do that. And again, inspection of property falls under the request for production of documents discovery method. Okay, so that is it. After break, we will, as I mentioned in class, we will go back and do the answers to interrogatory assignment, and then content-wise, sorry about that. Thought I was going to make it through without dogs barking. Almost did. Last thing I wanted to say is content-wise, we are moving on to deposition. So we are moving into chapter 14 after break. So have a good break. If you have any questions while you're working on the document request assignment, please email me. I'll be happy to get back to you. But otherwise, I will see you on March 12th. Thanks.